The trunk, the lies, the cell phone trail, all compelling evidence, but is it enough to convict Casey Anthony of murder?
Over the last few weeks, problem solver Tony Pipitone has laid out the timeline in the case against Casey.
Tonight, Tony takes it to the next level. What will happen when the gavel falls and Casey goes to trial?
On the defense side, Cheney Mason, prominent longtime criminal defense attorney. From the state's perspective, former Assistant State Attorney Elizabeth Rotter. Two experienced, respected legal minds asked by Local 6 to delve into the murky world of Casey Anthony. First, the venue, where the trial should be held.
From the defense side, is it in your interest to move this trial out of the county?
Well, it may very well be, but what county would you move it to that hasn't been saturated with this story? Prosecutions usually, almost without exception, oppose a change of venue.
Elizabeth, would you oppose it?
Yes, I would make the same arguments that he made. It's just that you can't go anywhere.
And Mason said seeking a change of venue could undercut another possible defense strategy. Issue number 2, demand for a speedy trial. Casey was indicted and arrested on October 14th, meaning the state has 175 days until April 7 to start her trial, unless Casey decides to waive speedy trial.
As a defense attorney, do you want a speedy trial in a case like this where there's no body?
Well, you know, that's an interesting question. Without the body, the state's going to have an enormous burden, and I don't think they can prove the case. Then I would certainly give strong consideration to moving on to trial without delay.
And there's nothing the prosecutor could do about it. Though without a body, you might think the state would want to wait as long as they could for trial, which raises the question.
And as a prosecutor, why would you even go to a grand jury without a body and force yourself to try this case?
It's a lot better to deal with witnesses while they're fresh. And the problem with a lot of murder cases is that they take years to try. And so if you wait that long, people's memories start to fade.
Mason has his own suspicions about the state's aggressive stance.
They thought that by bringing an indictment, charging first-degree murder, which could potentially lead to a death penalty, that would be coercive enough to cause this defendant to start talking.
But Casey isn't talking, and the clock is ticking toward a trial with no body.
It's the first day of your speedy trial, Elizabeth. No medical examiner, no body. What do you have?
But you're just missing a key witness, and so you deal with it. You work around it. You have Cindy, who smelled the dead body and said it smells like a dead body. You have George, who used to be a deputy, and he said it smells like a dead body. You have canine dogs that alerted on the car. And so there's a dead body. Now the question is, how many dead bodies does Casey Anthony drive around in her car?
Such a case has Mason chomping at the bit.
I'd love to see it. It's not going to happen. It can't.
Why not?
Because there is absolutely no evidence other than somebody saying they think they smelled what smelled like a dead body. What if they were right? What if there's a dead body? Does that prove that it was an unlawful killing? The answer is no, because not every homicide is murder. This child could have accidentally died in any number of ways, and they're never going to be able to prove without the body or a confession.
But the state does have one tool, scientific evidence. Chemicals indicating a decomposing human body were found in the trunk of Casey's car. Mason is not impressed.
They're going to have to present evidence to convince the court that such tests are generally accepted by the scientific community. And since you've called me, I've inquired. I'm not aware of a single case in which it has been admitted anywhere.
So is this hocus pocus science?
Well, yes. Yeah, you know, I'll just have to agree with that.
How can I put this person on trial for her life when the scientific evidence has not been used anywhere else?
They have to show that it's accepted in the scientific community. It's a hard, high hurdle in Florida to pass.
So that's going to be tough for the prosecutor.
Yeah. But it's helpful that it's corroborated.
Corroborated by a hair, also pulled from the trunk, a hair consistent in length and color with Kaylee's, showing signs of decomposition. DNA tests reveal it came from Kaylee or any of her maternal ancestors, from her mother Casey through her great-grandmother.
Is that not evidence of death?
I don't think that it's going to be proving that there was a death. It's proving it's an old hair with some tissue that's decomposed.
He's good. He's tearing apart the state's case here and basically says there is no case.
Every case is circumstantial. It has to be caught on videotape, right? I mean, isn't that the only way that it's not circumstantial? So here you have the smell of a dead body, you have chloroform in the trunk, you have somebody who's continually covering stuff up, making up lies, spewing stuff forth, and somebody that's missing. And so you prove it like every other case.
Without the body, the state is really in a hole.
It's really challenged.
I mean, really
Not
bad without the body.
Challenged, but not impossible, said the former prosecutor.
And the defense attorney sounds pretty confident there, but what if she is convicted?
If she's convicted of first-degree murder and the state decides to seek the death penalty, things really get interesting. Tomorrow at 11, we'll look at what Casey's defense team is arguing to try to avoid the ultimate penalty.
All right, we'll look forward to it. Tony, thank you.
Okay.
It has been the topic of a lot of controversy, but Local 6 has gotten to the bottom of it. We now know that George and Cindy Anthony do plan to write a book. They don't have a deal in the works per se, but they plan to put something together in the future. They say it won't be a tell-all book. Instead, it will focus on what families should do if their child is missing.
Without Kaylee's body, the case against Casey is being called circumstantial, even weak. What could be a disaster for prosecutors. But there still could be reasons to move forward with it.
And right now, Casey Anthony's trial is set for January, but many questions are hanging over this case.
How can the state attorney even prove Kaylee is dead, much less whether Casey killed her? Last night, investigative reporter Tony Pipitone took the case to trial. Tonight, he looks at whether the death penalty is even an option.
Whenever prosecutors finish presenting their case against Casey Anthony, the defense will ask the judge to throw it out, seeking a judgment of acquittal. Meaning, even with the state getting every benefit of the doubt, there's no way a jury could properly find guilt. When it came time to argue for acquittal, the criminal defense attorney on our panel, Cheney Mason, would be practically leaping to his feet.
How do you prove that this child is dead just because her mother won't say where she has been or is? If she knows, you can't prove that she's dead. If you can't prove she's dead, you can't prove the cause of death. If you can't prove the cause of death, you have a hard time trying to prove who's behind the cause or how it happened.
Former prosecutor Elizabeth Rotter says a circumstantial case could be solid enough to at least get to a jury.
Is it reasonable for a mother never to report her missing child? Is it reasonable for her to be quiet? Is it reasonable for her to never call the police? Is it reasonable for there to be hair in the trunk? Well, how often does her daughter hang out in the trunk of her car?
A trunk that reeked of death, and which scientists could be allowed to testify contained the remains of a decomposing human body. So for the sake of our experiment, let's say the state's case survives and Casey can offer a defense. Motion for acquittal denied. Do you put her on the stand?
What I know about the case this time, there's not a snowball's chance, where in me putting her on a witness stand.
And why is that?
Well, because there's so much to cross-examine her about.
The prosecutor, much as she might like it, cannot force Casey to testify. So other than cross-examining the state's witnesses, the defense's work may be done. You just say the defense rests. Don't even put on a defense.
Well, there's a good chance that would be the case.
So that would leave Casey's fate to a jury. Right now, she's charged with first-degree murder, aggravated child abuse, aggravated manslaughter, and 4 counts of lying to police. Sometimes juries are given a chance to compromise on what's called lesser-included offenses. It doesn't have to be murder. It could be something lesser.
It could be murder, first degree, second degree, or manslaughter.
Either side could ask that those choices be given to the jury.
Most likely the defense is going to say, we just want what's charged and nothing less.
If the case against Casey is as weak as Mason claims, she and her attorney may choose to roll the dice. The defense would risk all or nothing?
Some defense attorneys have done that. You either come after murder one or you have to acquit.
Again, for the sake of argument, let's say the jury finds Casey guilty. Guilty of premeditated murder or murder in the commission of aggravated child abuse. Either way, the case would turn to life or death. That is, if the state even seeks the death penalty. To get it, the state would likely have to show the death was heinous, atrocious, or cruel.
How do you prove the aggravator of heinous, atrocious, and cruel if you can't prove the cause of death? Because you don't have a body.
There's a dead child. How more heinous and atrocious and cruel can there be?
Because people die by accident. People die of natural causes. People die any number of ways. Absolutely no way. No possibility of proving heinous, atrocious, and cruel without the body.
And there are other so-called aggravators.
Is that cold, calculated, and premeditated?
I think you could definitely argue the cold and calculated.
How do you prove cold, calculated, premeditated, again, if you don't know when or how or why?
The state could also argue a child victim being killed by a caregiver supported death penalty, but on this question, both our defense and prosecutor sides have some agreement.
As it stands now, you can't get there.
So there's no way you'd see a death penalty in this case?
No.
Based on what we know now?
Based on what we know now.
I don't think the state would go through with it if they don't have a body.
That they wouldn't go even to the death penalty? They wouldn't even seek it?
Right.
Without a body?
Then there's the other possible result.
Not guilty on all counts. Is that justice? If she walks out of that courtroom a free woman?
If you believe in the Constitution of the United States, and you believe in a jury system, then you must necessarily conclude that that was justice.
And on that, they both agree, Jacqueline.
I know pretrial motions are next week, and the trial is set to begin in January.
January 5th right now, but if the defense does not waive Casey's right to a speedy trial, the clock is ticking, and the latest a trial could start would be April 7th. So all this could come to a head very soon.
All right, Tony, we'll be watching.
Now, since 6 o'clock, we touched base with George and Cindy Anthony hours after their attorney severed ties with them. And tonight we're learning that they're most certainly going to look for another lawyer. Local 6 reporter Jessica D'Onofrio is in Orange County tonight. Jess, what'd you find out about their search for an attorney?
Well, Bob, I talked to Cindy a little while ago right here in front of their East Orange County home, and she told me that right now she feels like they don't need an attorney, but she says she is certainly planning on looking for one very soon. George and Cindy Anthony tell Local 6 off camera tonight that they're now looking for new legal representation. Today, their high-profile Orlando attorney, Mark Nejame, quit.
In order for me to represent a client, I've got to be the one in charge of the case and the client. And I felt like I didn't have the requisite control.
Nejame says he had no control over George and Cindy, saying he could be of little value since they've been choosing to act and comment at will.
Yeah, this is Kaylee's room. This is very hard to come in now. People are starting to send Christmas presents to us already for Kaylee.
Just this week, the couple allowed me exclusive access into their home to talk about the search for their missing granddaughter, Kaylee.
Having Thanksgiving come, it's not going to be our normal, Thanksgiving.
Nejame says our report was not the straw that broke the camel's back. Instead, he says it was a series of incidents that led to his decision.
If I'm providing service as an advisor, then it does little good if my advice is not followed.
Tonight, both sides say there are no hard feelings, and the Anthonys released a statement thanking Nejame for his efforts. But now they're left to fend for themselves, while investigators press them for information about their daughter, Casey, who's charged in connection to the murder of their granddaughter. Back here live, we were expecting the Anthonys to have a press conference sometime tomorrow. They were going to discuss in more detail why they believe Kaylee Marie is still alive. However, today, they abruptly canceled that press conference. For now, I'm live in East Orange County. Jessica D'Onofrio, Local 6.
Well, just Mark Nejame's no longer there to tell them not to hold the news conference. Why'd they call it off?
Well, all they said in their news release today was that due to the developments this week, they thought it was unnecessary, but they wouldn't really be specific about anything else. Bob?
I'm sure we'll hear from them shortly. Jess, thank you.